The first case to come before us this morning is In Re BW and HW. Both sides will have 15 minutes to present oral argument. If you are the appellant, you may reserve up to 5 minutes for rebuttal. If you would let me know when you get started, how much time would you like to reserve for rebuttal? I'm keeping the clock today. Please don't use the names of any minors or victims. You're both very experienced appellate counsel, so I'm sure you know. But we are live streaming this and also recording it to be placed on our YouTube channel. We have read the briefs and are ready to proceed when you are.
Great. Good morning, Your Honors, and may it please the court. I am Alan Medvick. I'm here representing the mother, the appellant in this matter. This is a juvenile dependency matter involving the removal of 2 children and an effort to bypass reasonable efforts to return those children. Just to make clear the timeline in this case, when this case was filed, when the complaint was filed on November 23rd of 2020, the permanent custody motion was attached to that motion. The agency, at the inception of this case, intended to remove and terminate the parental rights of this mother from the first moment of the case. And approximately 2 months later, they filed a motion to bypass reasonable efforts based on the prior involuntary termination of parental rights of the mother's other children. In that case, and in this case, the complaint was filed with claims of neglect and dependency under all 4 subsections of 215104C. After the adjudication hearing, the magistrate dismissed the findings of neglect and dependency under A and B as unproven, finding dependency under subsection C and D. On objection, the judge sustained the objection as to subsection C and dismissed that count as unproven and sustained only under subsection D, which is based on a prior adjudication of children and circumstances continuing, and that because of those circumstances, the child was at risk of neglect or abuse. I would contend that there is no evidence that the prior adjudication of those children in any way impacts the children here. That case was tried. The facts of that case, as indicated in the complaint and indicated in the judge's decision, arose in 2016, some 4 years earlier than any of the facts asserted here, involved completely separate children, involved outside the mother, completely separate adults, a completely separate residence, and a completely different set of circumstances. There are absolutely no overlap to justify the statement by the trial court that because of the facts and circumstances outlined in the mother's prior neglect and dependency case, the children here were at any risk of neglect or abuse. And the trial court, in its decision, in overriding and overruling and dismissing the claims under dependency C, states that that there was no specific evidence of any fact or circumstance which was detrimental to the children. That's a statement directly from the decision. They said the police officer investigating the home did not believe that the condition of the home was a concern. There were concerns, but unestablished evidence that mother was at any risk of losing her home. There was no evidence of a pattern of domestic violence between mother and her paramour. And all of those things are stated as a basis for dismissing subsection C. However, under subsection D, the court then decides to state that mother was in an abusive relationship with her paramour in the home, that has allowed a drug user to reside in the home. I would point out that there is no evidence of drug use or drugs of any kind found in the home. The alleged drug user had a separate residence with a separate entrance and egress that could be locked from the children's residence, and that there were questions about the cleanliness of the home. The agency, the judge also points out and states that mother was not cooperative with the agency. That is absolutely not a basis for any consideration of dependency. There's no obligation at the time of shelter care. There was no warrant. There was no order of court requiring the mother participate or cooperate with the agency in any way. There was no access order sought that was denied. There was no case plan in place. There was nothing that would require cooperation by the agency. That in and of itself cannot be a basis for dependency. And all of the other stated facts, they've already stated there was no evidence of in the prior paragraph dismissing subsection C. There's no consideration to or basis for or evidence to support a finding under the second prong of dependency D. For that alone, I would ask that this case be dismissed and the decision of the trial court be reversed. Be clear that this case is the caseworker herself indicated that she had gone into the home, stated that there was no basis to remove the children from the home, and her sole basis for returning was based on finding out that there were prior cases involved, that there had been prior children involved in this matter, and that is their sole basis for returning to the home and removing the children. I would also point out, I'm sorry.
That's okay. That's okay. But isn't that the whole point of the statute? You know, that you don't have to wait for the children to be in a horrible situation. And so
I would
go ahead. Mm-hmm.
I would say no. I mean, I would stop short of saying a hard no. There has to be something. There has to be some evidence, something beyond mere conjecture. I think this would be analogous to the statements in a Terry stop are you can't just go on a gut feeling. And I think that at worst here, at best here, we have a gut feeling. I think we have less than that. I think we have an investigated home that showed no issues, nothing that would rise to the level of concern. The police left, and Officer Hassamussen, who investigated, saw no issues. The agency's own intake worker who investigated saw no issues. And at that point, there was no, and to be clear, the dependency D statute has to speak specifically to abuse and neglect. It can't be a likelihood of dependency that would give rise to that dependency. And there was no indication that these children were going unfed. There was no indication that there was a likelihood of abuse toward those children. It's just not there. There's nothing in that record to indicate that. There's literally no fact at all that points toward neglect or abuse in the record. Outside the fact that in 2016, in a completely different home, in a completely different space in her life, she did have her children removed involuntarily, and her parental rights are involuntarily terminated. I want to point out that the oldest of these children was in fact born during the pendency of the prior action with those 4 children, around the time of the permanent custody hearing, and a case was opened at that point. That child was returned to mother's custody at that time. Mother had obviously gone and made significant changes in her life and put that situation that gave rise to those conditions, those prior to conditions as asserted in 2016, had addressed those issues and dealt with them. And so to claim now that because of those conditions, which don't exist here, they just simply do not, and are not relevant to, or no part of that condition that is a cause of any harm or risk of harm to any of these children, to either of these children. And so, yes, you don't have to wait for an active harm, but you have to have some basis to move on, even under a lower standard of demonstrating a likelihood of abuse or neglect under subsection D2. And that's not here. So, and again, which brings us to the second assignment of error, which is that the agency has sought to bypass their requirement to make reasonable efforts at reunification. They've filed the permanent custody action with the complaint, and then early January, they moved to bypass reasonable efforts and have this matter proceed almost immediately to permanent custody. And I believe and have always believed that the subsection in this statute is facially unconstitutional. It denies a certain segment of the population their due process rights. It is an equal rights question, an equal protection issue, because it is not rationally related to any compelling government concern. And I would point out that absolutely the state has a concern and an interest in maintaining healthy children and in making sure that children are not being abused, neglected, or left as dependent. But that is not what this subsection addresses. It addresses only the involuntary termination of parental rights and not all. And it sets up a situation where similarly situated persons are treated differently. And in that regard, I could have two identical cases which would go through the same pattern and proceed to a permanent custody hearing. If one parent were to voluntarily relinquish her parental rights and the other were not, the first parent would absolutely have a right to reasonable efforts at the next hearing. And the second would have those denied, simply not based on any of the actions or any of the concerns relating to the children, but based solely on the action of exercising her trial right.
Counsel, I just wanted to let you know, I don't think you reserved any time, but you're at about 4 minutes, so.
And if I could reserve that time, and I apologize, I get way out ahead of myself sometimes.
That's okay.
I'd hold on to those 4 minutes for rebuttal. Thank you.
Certainly. Counsel for the state.
May it please the court, Heaven DiMartino on behalf of Summit County Children's Services. We are asking that this court affirm the trial court's decision adjudicating these children to be dependent under 215104D, as well as uphold the decision that the reasonable bypass statute is constitutional. With regard to the first assignment of error, there's no dispute that the first prong is met, that this mother had her parental rights involuntarily terminated. With regard to 4 out of 5 children in the prior case, the other child went to the legal custody of a relative. So that remains the analysis for the second prong, which talks about the circumstances surrounding the termination of parental rights with the other siblings, and then the conditions in this household and the circumstances that are going on. Do they present a danger of neglect or abuse for these 2 children? Well, the prior acts, when you look at them, show that mother has had a long history with Summit County Children's Services. She has a pattern of abusive relationships which lead to neglect. The house conditions in the prior case, the house was deplorable. There was a lack of food. She had unworking appliances. The children were left in one room and not supervised. In this case, mother had a gash between her eyes, 2 black eyes. She's been uncooperative with CSB. She's allowed known drug users in her home. The boyfriend was arrested when the police came to do a welfare check for a warrant. Another man was in the house named Mike. He had a warrant. They were both removed from the house. Mother could not tell the agency who she lived with. She didn't have a lease. She said she wasn't paying the rent. She is engaging in that same pattern that put the other children at risk, that led to the agency filing dependency neglect abuse action for those 5 children. So there is a nexus between her past behavior and the current conditions that make it appropriate under 215104D for the agency to file and for the court to find for prospective dependency. The point of that statute is to protect children and not force the agency to have to wait until a child is actually harmed. So the agency would disagree with the analysis by mother and mother's counsel and would argue that the analysis that the court engaged in with respect to the current conditions of the home, and then comparing that to the conditions that brought the other children into the care of the agency and caused her rights to be involuntarily terminated, support that finding. As far as the constitutionality of the reasonable efforts bypass statute, The only case that I could find that looked at that statute was from 2010 by the 2nd District. And then that is that In Re KW case, which was decided after permanent custody. So it does seem to me that it's probably premature to raise a facial not a facial analysis, I'm sorry, an analysis of the statute as applied here, because truthfully, when the dispositional hearing happened, the court actually found that the agency engaged in reasonable efforts in February, even though we had filed for the bypass in January. So for a mother to argue on its face the statute's unconstitutional, I don't know how that really can work right now when there was actually a finding that the agency did engage in reasonable efforts. And in fact, the agency did develop a case plan. There were referrals for mother to get services. She's gotten bus passes. The motion for permanent custody that's pending now was not filed until February. And we did try to work with mother. Like I said, mother is uncooperative. The statute, as far as on its face, the state would argue that it is constitutional. Statutes are presumed to be constitutional. There is clearly a compelling interest for the state to protect children and to be able to expedite things to some degree by allowing the agency to not have to engage in reasonable efforts. But it only goes to one prong, really, of the permanent custody statute. That first prong, whether the agency could not or should not place the child with the parents if we're going to go, faster than waiting for the 12 months. So that's just one prong. We still have to prove best interest. So this does not create a special class or a protected class. It doesn't treat, two folks going down the same path when the agency gets involved differently. They're vastly different. We're working to still engage in reasonable efforts, at least through adjudication and disposition. There was a case plan filed in this case in December with the goal of reunification. So it's disingenuous to say that the agency did not make any efforts towards reunification, regardless of whether there was a prior permanent custody motion that was filed. But this is not designed, the statute, to punish parents. It's designed to protect children. And I think that's the way that it needs to be analyzed and examined through that lens. So based on those arguments, unless there are any questions from the court, I would rest on my brief, other than just to point out the timeline really does reflect that mother was given time and an opportunity to try to work a case plan. She did not do that. The agency did file for reasonable efforts bypass, but that was not until January. Shortly after that, the court did find that there were reasonable efforts that were made by the agency, and that permanent custody motion that's pending for a July hearing wasn't filed until February of this year. And if there are no other questions, I would rest on my brief.
Seeing none, thank you, counsel. Mr. Medvick, you have 4 minutes for rebuttal.
Thank you very much. The state's attorney, the prosecutor, is absolutely wrong about the timeline here and the suggestion that a case plan was implemented and that what the client was on, and my client was uncooperative with that case plan. First of all, a case plan is not adopted until disposition. All of these actions and these discussions here are involving adjudication and pre-adjudication issues. The suggestion that because it states that reunification was on the table or was a stated goal, it's a fallacy. The permanent custody motion was filed. The dispositional outcome has always been intended to be permanent custody. There's no case plan in place that mother has to oblige by or cooperate with at this point. To put the cart in front of the horse and say that she had to cooperate with the case plan because she and that somehow implicates adjudication is simply wrong, which would bring us to the In Re KW case and the suggestion that while the need to show best interest remains for all parties, the suggestion is the fact is that there are two obligations for the agency in almost all cases. One is to make reasonable efforts at reunification, and two, to demonstrate it's in the best interest that permanent custody be granted. In this case, you can't simply say, well, the second prong is still there, so we can just ignore the first one. We're talking about the fact that they are being released from a legal obligation simply because the client previously exercised her trial right, or as I think the judge pointed out at at the hearing, at the trial level, even if a parent is absent and his or her parental rights are terminated involuntarily based on lack of awareness, that would implicate this statute at a later point as well. It's facially unconstitutional, and it is also, I believe, appropriate for consideration before this court as a grant of a provisional reprimand from which there is no recourse at a later. I mean, there's no reasonable appellate right to come back and hear this again later. The trial court, if the trial court were to grant permanent custody, having not engaged in reasonable efforts, we can't then go and get that year back. We're talking, as has been pointed out, we're talking about the care and well-being of children, and the destruction of a parental relationship over the course of a year or longer while a child is removed cannot be undone, and that this is an ancillary action that and a provisional remedy that I think could be heard by this court. While I would ask that this court reverse the adjudication decision, and which would probably render the subsequent finding moot, I would absolutely believe that this needs to be heard, and that provision is facially unconstitutional. And the mere fact that they still have to make best efforts, as they would in any case, doesn't change the fact that they're being relieved of a legal obligation here. Lastly, I would point out that the Juvenile Rule 6, under its bases for taking a child into custody, does not list dependency D as a basis for doing so. Under Rule 6A4, it says that a child can be removed if a judge or designated magistrate, under 3G, if a juvenile judge or designated magistrate has found probable cause to believe that any of the conditions set forth in A3, B, or C are met. So subsection A4 is not actually a basis for removing a child at a probable cause level, let alone here. So while
And
I
counsel,
don't believe there's any, I'm out of time.
yes, I'm
Well,
sorry.
We'll leave it there. I have a lot of words on this one, so I apologize. I want to thank you for your time.
Thank you both for your presentations this morning. Court will take the matter under advisement. We will issue a written decision, which will be mailed to all sides as well as posted on the Ohio Supreme Court website. Have a wonderful day. Best of luck to both of you.
You too.
Thank you.
Thank you, Your Honor.